judgment in the appeal, Sadovska and another, and the Secretary of State for the Home Department.
Lady Hale will explain the judgment of the court.
Ms. Sadovska is a citizen of Lithuania. She moved to the United Kingdom in 2007. She has lived and worked here lawfully ever since and has acquired a right of permanent residence here as an EU citizen. Mr. Malik is a citizen of Pakistan who entered the United Kingdom with a student visa in May 2011 and has remained here unlawfully after his visa expired in April 2013. It is their case that they met at a disco in Edinburgh in 2012 and decided to be in a relationship on St. Valentine's Day in 2013, and then decided to get married when they were on a trip to London in January 2014. Accordingly, they arranged a wedding at the Leith Registry Office on the 27th of April 2014 and alerted the immigration authorities to their plans. But it was not to be, because the immigration officers turned up at the registry office, interviewed each of them separately, and concluded that the marriage was a sham. Each was detained and issued with a notice of intention to remove them from the United Kingdom. They appealed to the first-tier tribunal, which refused their appeal. The judge stated at the outset that the burden of proof in immigration cases lay upon the appellants. They had not satisfied him that their proposed marriage was genuine. They appealed unsuccessfully to the upper tribunal and to the inner house of the Court of Session, and now appeal to this court. They argue, first, that the tribunal was wrong about the burden of proof, and second, that their interviews were unfair. The problem with the approach taken in the tribunals and the court below is that the legal position of Ms. Sadovska is quite different from that of Mr. Malik. He is an overstayer and liable to removal from the United Kingdom unless this would be in breach of his rights under the European Convention on Human Rights, such as his right to respect for his private and family life, or his rights in EU law. Had he succeeded in marrying Ms. Sadovska, he would have acquired a right of residence in the United Kingdom as a family member of an EU national working here. Member states are also required to facilitate the entry and residence of the partner of an EU citizen if they are in a, quote, durable relationship duly attested, end quote. Ms. Sadovska, on the other hand, has a right of permanent residence here and can only be removed in very restricted circumstances. These include that she has abused her rights, for example, by entering or attempting to enter into a marriage of convenience. A marriage of convenience is one in which the predominant purpose of both parties is to gain an immigration advantage. This is not the same as a marriage which has that as an incidental effect. The Secretary of State may take steps to remove an EU citizen on the basis of reasonable grounds to suspect that she has entered or attempted to enter a marriage of convenience. But she is entitled to an appeal where the facts and circumstances are fully investigated. The tribunal has to form its own view of the facts from the evidence presented. It was not for Ms. Sadovska to establish that her relationship with Mr. Malik was a genuine and lasting one, but for the Secretary of State to establish that it was a marriage of convenience. The tribunal had also to be satisfied that even if it was, the removal of Ms. Sadovska from the country where she had lived and worked for so long and had other family members would be a proportionate response to the abuse of rights, rather than merely to prevent the marriage. In Mr. Malik's case, the burden was upon him to show that he had established a private or family life here, or that his relationship with Ms. Sadovska was a durable one, in which case the Secretary of State would have to justify removing him. It is possible, therefore, that a tribunal might reach a different conclusion in respect of each of them. But clearly, this tribunal had not adopted the proper approach to these appeals, and this court could not be confident in either case that had it done so, it would have reached the same conclusions. Accordingly, the court unanimously allows the appeals and remits them for rehearing before the first-tier tribunal.